I'm Betsy Urbance, and joining me today is Annalise Fierstos, our legal hotline attorney. I'm the general counsel currently for Illinois Realtors, and today we're going to spend a little time with you doing our RELA, as we call it, or RELA, however you want to say it, the Real Estate License Act. That's our own acronym that we made up, isn't it? Catchy? But we're going to do a live session with you. We've gotten some questions in. We thought we'd do kind of an overview of where we are now, the different categories of the statutory provisions, and something about rules that we hope to someday have. And we've gotten some questions in advance. We'll take those up within the context of our presentation. Annalise and I will be switching off. Hopefully you are all, if you're a participant, you are now muted, and you will probably stay that way. So if you wish to ask a question that is not answered in the course of our presentation, you can certainly do that by means of the chat function. And we have really good, able assistant monitoring our chat so that we will get those questions, and assuming we have time. So without further ado, let's just talk about where we are now. The RELA, or RELA, Real Estate License Act, was substantially rewritten, not entirely rewritten, and there's a whole long story that will not bore you with the details here in this session today. But the bottom line is that the substantially rewritten License Act became effective on August 9th, 2019. And there's Annalise. So, okay. So anyway, let's switch back and forth, Annalise. So I don't know who can see what, but you and I can switch back and forth maybe. But then a question that did come in, and a question we all have, and I have to admit that I share these questions with you, is whether and when there will be rules in place that will clarify and help us to administer the newly adopted in August 2019 License Act. I'll tell you that industry, that's us, and IDFPR have some conceptual agreements, and there is a draft of rules out there in the world. Well, it's not in the world yet. It's just a draft of the rules that's going up the food chain at the Division of Real Estate, or the department, or the department for finalization. It also then would need to be approved by the governor. He's a little bit preoccupied. His office is a little preoccupied right now in the wake of all the world events and the state events. But the governor's office has to sign off. Once the governor's office signs off on the draft, they are filed and published for notice and comment. Bottom line on rules, I think we're lucky if we're 6 weeks away from publication. I think we're lucky, but stay tuned and we'll let you know as we get more details on when those rules are published. But we are going to talk a little bit with you today about what our conceptual agreements are with regard to what the rules will look like. So also, I want to say to the brokers that are in their current renewal cycle, and April 30th was the date to renew. Now the deadline has been pushed to September 30th. And I would just suggest to you that if you are a broker licensee that's not a brand new broker licensee, or if you're a brand new broker licensee that got your license in between August 9th, 2019 and November 1, 2019, you need to get either your CE done as soon as possible, or your broker pre-license, which we'll talk about, the 45, or the post-license, excuse me, that you need to get done prior to September 30th. For those brokers that have been brokers a while and all they have are 12 hours of CE to do it as soon as you can. Do not wait till September 30th, because there's a whole bunch of other licensees that will need to renew on that same date. And I promise you that the department will have delays. So that's just a little commercial for getting your CE done if you're a broker. Annalise is going to share with you broad categories that we've kind of come up with on our own as far as how the provisions of both the Real Estate License Act and the rules are divided. So Annalise, you want to share with us those categories?
Yes, thank you, Betsy. And good afternoon, everybody. Thank you again for not only signing on today, but those of you who took the time to send in advanced questions. That helps us a lot to narrow and address things that are of concern in the industry. And as usual, I can see myself now and I'm really close to the screen. But a couple of the things that have come up quite often and that we are going to address are paperless practice and technology. The new RELA rules do take the time, or they are structured in order to focus on an ability to practice in this new virtual world. It's very timely given the last several months and the movement of the industry and all businesses to a lot of remote work. So it's a very timely time for us to be introducing the new law. It works well, and it's and everybody, all of us, are educating ourselves a lot on how to work this way. So we're probably a few steps ahead this time. The other thing that we're going to address is new education and oversight responsibilities that are outlined by the Act. We're addressing teams and advertising, which the new advertising rules, particularly with respect to teams, those have been at the forefront of the hotline questions, and all the way up until the middle of March when a lot of the COVID-related questions started to come in. But teams and advertising have been a consistent concern among the members of Illinois Realtors. Finally, we are going to discuss consumer protection issues and a little bit about the revamp of the recovery fund. Betsy will be discussing that. And then finally, we do have a few catch-all and miscellaneous provisions. That being said, I'm going to turn things back over to Betsy for a moment, and thank you.
Okay, so we're going to address, Annalise gave you the broad categories: paperless practice, education and oversight, teams and advertising, consumer protection. I'm going to say a super little bit about the recovery fund, only that it was prior to the rewrite, it was almost impossible to get to it if someone had been harmed financially by a bad acting broker or a bad acting licensee. And some of those restrictions have disappeared from the Real Estate Licensing Act. So now theoretically, it might be easier to get some relief in a situation, say, where a broker steals a whole bunch of escrow money and there's just literally no recourse for the consumer or even the broker that's been harmed. Sometimes it's brokers. Let's not go down that rabbit hole. But anyway, that's all we were going to really say about that. And we have some other some pressing consumer protection questions that we're going to get to throughout the course of the program. We're going to address these broad categories in order. And Annalise is going to start us off with paperless practice and technology, addressing a question that we did get in prior to the session.
Thank you very much, Betsy. First, just so everybody knows, we took the questions and we broadened a few of those and made them so that they encompass some of the other concerns that were coming in on the hotline as well. But one of the questions that came in was, is there a requirement for branch licenses under the new Real Estate License Act? Not really, not anymore. RELA has been redrafted so that the term branch has been essentially eliminated. Now I say that, but if you get on and you start filling out paperwork on the department's webpage, you will see the term branch used because they just haven't revised all of the verbiage on their webpage yet, but don't let that concern you. Currently, you don't need a separate license for every office. You will have your main office listed with the department, and then you will, in the same application or registration, you will list your other offices, but they will not be called branch offices. Each branch office does have to have an assigned designated managing broker, and one designated managing broker can run more or be in charge of more than one office under their sponsoring broker. If your offices are actually physical offices, you'll still need to comply with all of the old requirements for the physical offices, and that would include having a sign for the office that is required, and records that are maintained You can either keep a physical record, or if you are keeping them in the cloud, you do need to make certain that those are accessible in the event that there is an audit or they're requested by the department. You do need to make sure that they are readily accessible. If you have a physical office, the rule still does exist that that physical office cannot be located within a retail or financial business establishment, and that it has to be clearly separated from any other business within the establishment. So it has to have its own distinct area. So although the term branch has been removed, the requirements for the physical offices do stay in place. I'm going to turn discussion back over to Betsy. Thank you so much.
Okay, so then all of this discussion about offices and branches and lists of offices turns us to the question of virtual office. And we've gotten this question on several occasions. Is a virtual office permissible under RELA and in parens future rules? And our answer to that question is yes, you may operate by means of a virtual office. And when we say that, we're sort of talking in the context of you would have a website. And if a consumer is going to walk through your virtual door, they'll have to go through a series of steps, password, username, something of that nature to get into your virtual office. So you sort of analogize everything with your virtual office to compare it to a bricks and mortar office. So what do you have to do? Well, you have to do everything that RELA requires, and that is protect the confidentiality of your clients, and that is record keeping. You have to meet the record keeping requirements of the License Act and the rules. You have to be able to lock your virtual files, so only those with appropriate permissions can get into those files. Someone ultimately with appropriate permission that would have to be granted could be an auditor or an investigator from the department. So let's say you've got your virtual office, you're operating your website, you'll probably have to have a physical location, not as your office, but as a way that the department can serve process on you. So there probably will be a requirement to have at least an address, a physical address on file, but your office could be your website. You'll have to meet the advertising requirements. So the name, your sponsoring broker's company name, will have to be on the homepage of the website, meeting all the advertising restrictions that we're going to talk about in more detail later. Escrow handling will have to be dealt with electronically. To my mind, a lot of the electronic transactions financially, as long as you're aware of the wire fraud and the potential cybercrime, but as long as you're doing it very carefully, it's almost easier for a designated managing broker to oversee the activities of the sponsored licensees in dealing with escrow funds, because you can actually get in the chain of command, if you will, electronically. Office policies, supervision and oversight, all of those things are required in the same manner. So I think you can expect that the rules will dovetail with what RELA says, and the rules will be written in such a way that if you're operating a virtual office, all of those requirements will apply on the electronic platform. So I think that's kind of what you can expect. Then along the same lines of practicing in a virtual world or mainly electronically, paperless practice and technology being the theme of this particular subject, the sponsor card, the paper sponsor card, or the 45-day permit, it's my understanding that it's not completely dead yet, but I think it will be quite soon. And the concept of sponsorship, if you've changed your sponsorship recently, or you haven't been issued a new license, you're in sort of the state of being sponsored or sponsorship. So your proof of licensure would be an electronic copy of a license that you might be able to show on your phone, or if you're still a paper person, like in many respects, I'm still a paper person, you would print if you want to, cut it out, laminate it, put it in your wallet, you're good to go. Or you can show somehow that you are properly sponsored by use of some other technology. So it's really the concept of sponsorship. You'll see that the sponsor card, the 45-day permit, references to paper have pretty much gone away when it comes to sponsorship in the License Act. Also, one thing of great importance to both sponsored licensees and sponsoring brokers, and therefore the designated managing brokers who run the companies, is this termination. And how is someone terminated? Well, if I'm a designated managing broker and I'm going to terminate Annalise, that was pretty easy with paper, because I would tell Annalise, I'd sign off on her license and I'd give it back, and then she was free to go to another license. Now we do that electronically. I would go into the portal, I would terminate Annalise's license. Hopefully she knows about it. And I had an obligation to notify the department. Well, the opposite situation presented a bit of an issue when licensees could terminate themselves from their sponsoring broker. They go into the portal, they terminate themselves, they steal all their files, not all of them, just some, and they take off, and then 3 weeks later, their sponsoring broker, their designated managing broker for the company, finds out that they're long gone and they're actually working for someone else. So the rules and the law require and will require that the licensee, when the licensee terminates, goes into the portal, takes themselves out of their current sponsoring broker, they must immediately notify that sponsoring broker that they are leaving. And they should look at their contract, because if there's nothing in their independent contract to the contrary, all those listings belong to their sponsoring broker, and it would be inappropriate for that licensee to take them with. And there are actually some license law and Realtor Code of Ethics problems if and when they do. We don't want to make this into a whole different webinar, so I'm just going to say those things and move on. But know that the goal with rules and with the infrastructure of the department is to actually produce a copy. Anytime either a sponsoring broker terminates a licensee, copy goes to the non-terminating party. So that is the aspirational goal. It happened once before and literally blew up the department's computer system. So moving on to the next topic so that we can cover everything that we've prepared for and even take some of your questions that I see popping up in the chat here. Annalise is going to share with us stuff on education and oversight.
Thank you. So one significant change under the education and oversight provisions is that broker licensees can now be 18 years old and obtain a real estate license. So it kind of boggles the mind, because I have an 18-year-old at home. So it's just something to really think about, but it's a great opportunity for young people to start getting into this world. So another change, though, that is going on is that, or that's happened, is that pre-license education is now 75 hours, and post-license education is 45 hours divided into 3 separate 15-hour classes with a 50-question test after each section. Those include, the 3 classes are Applied Brokerage Principles, Risk Management and Discipline, and Transactional Issues. So you would take each one and then you would do your 50-question test. Along with another section that would be a good one to actually read is Section 10-55 of the Real Estate License Act, and that addresses the responsibilities of the designated managing broker. And now we keep using designated managing broker because it's a relatively new term. So I'm just going to back up a little bit on advertising, or maybe move forward, but the term designated managing broker is now required for anybody who has been assigned by the sponsoring broker to be in charge of the office. So the designated managing broker does need to include the term designated in their advertising. That being said, along with that new title comes new responsibilities. A designated managing broker has quite a few new responsibilities. Actually, they probably should have been doing these, but now it's all defined and it's clearly defined. It's not left to independent decisions. They establish company policies for their office. They establish training for the office. They provide assistance to all of their licensees, and they supervise all special accounts, including all escrow accounts. With respect to those 18-year-olds and the young ones who've come in and or somebody who's a brand new licensee, those who have not completed 45 hours of post-license education, it addresses that so that they're taken care of and they are looked out for a little bit more by these designated managing brokers. So if you have an 18-year-old who's about to embark on this, they have some guidance. So the designated managing broker, for those who have not completed the 45-hour post-license ed, the designated managing broker handles their escrow money, their earnest money, and their contract negotiations. And they do approval of all of their advertising. They also, those licensees who have not completed that post-education 45-hour requirement, they cannot enter into any transaction and bind their company until after they've completed that education. So those are some significant things that have changed, great changes in the act, because it's tightening things up and it's making sure that those new licensees are looked out for, and the managing brokers have very clear roles. I am going to turn back over to Betsy, and she is going to address some of the other training requirements, specifically sexual harassment training.
Right, and we were going to talk about CE in general. Just a couple things to dovetail, piggyback on what Annalise shared with you about the designated managing broker and responsibility for new broker licensees. 18 is the threshold number now, so 20 is the corresponding threshold age for a new managing broker, because you have to be a broker for 2 years. The other thing is you don't have to be 18, you can be 57. So if I'm 57 years old and I go get my broker license, I'm going to be subject to all of the oversight that I would if I were younger, until I get my post-license education done. And the whole idea on the post-license, and Annalise gave you the subject matters, is that they be real world type case study, and you've had a little experience already. So more trying to give you sort of real life experience before you're flying off on your own. And with regard to binding the company, that would include like brokerage agreements, listing agreements. So that's something that when a designated managing broker before could delegate that responsibility, they really cannot delegate that responsibility to a new broker licensee until that post-license education is complete. With regard to continuing education in general, there's a new citation process in RELA, and there will be some corresponding rules with regard to that citation program. And what that means is essentially that they're taking the failure to timely complete continuing education kind of out of the formal disciplinary process and making it something that, you know, you had challenges or whatever, there was a global pandemic, you couldn't get your CE done in a timely manner, and you will get now a citation if you haven't completed your CE before your renewal when you were supposed to. And you could, let's say you get a citation from the department, but for whatever reason, they don't have your records on file, but you do have your legit records in your own file. You can prove that you did your CE, and then it's a non-event and you move along. If you get that notice, you can ask for a hearing in 30 days, or you can waive that hearing, get your CE done in that 30 days, and pay a fine. And the fine will be something like $500. So it's significant enough that hopefully you're incentivized to do your CE in a timely manner. But if you don't, it's going to hurt a little bit. It's not going to be a full-blown disciplinary matter unless and until you become a total scofflaw and you don't do your CE and you don't do it, and the fine's going to keep getting higher and higher until finally it will be formal discipline and you'll be subject to all of the possible penalties under the Act. And then, as Annalise alluded to, the sexual harassment prevention training. That has now been required of any licensee licensed by the Department of Financial and Professional Regulation for probably about a year now. For real estate licensees, it is included in the elective portion of CE, and it's 1 hour that's required. So that was one statutory requirement. We know about it. It's built into a lot of CE course packages, and you would take that and satisfy your requirement. Then there's another statute that just recently came into being, I think effective Jan 1, 2020, that was put forth by the Illinois Department of Human Rights that requires now every employer in the state of Illinois who employs, or in our case, sponsors independent contractors, and more than one of those people, there's a requirement to do an IDHR approved sexual harassment prevention training. I call it SHPT because it's such a mouthful. So that's yet another requirement. Bottom line is, for licensees and for brokers overseeing offices, everybody in their office is going to have to do SHPT at least once a year. Real estate licensees will probably do the CE version of SHPT every other year before they renew their license. And then they could take, there is a program, it's a program of a series of slides put out by the IDHR, the Illinois Department of Human Rights, that will satisfy your requirement. They could do that in the off years. I'll tell you that Illinois Realtors is using the IDHR slide program because, according to statute, that is the one that meets all the requirements that IDHR has. Honestly, I think some of the CE courses that I've seen are better, so you don't have to do the IDHR. But just so you know, there are two different requirements. Bottom line is, everybody's going to have to do some SHPT training every year, whether you're a licensee or not. So that covers the first two big subject areas. I'm going to turn teams and advertising over to Annalise to answer the size questions.
Thank you, Betsy. And just, we do see your questions rolling in too, so don't worry, we will flow back to the questions that are coming in at the end of the presentation. And so we just don't want to get off track, and I don't want anybody to get worried that we're ignoring you. But one of the biggest things that the hotline was dealing with right after the new License Act was made public to everybody and everybody started to review it was teams and advertising. And one thing I do suggest is pull up section 10-30 of the Real Estate License Act and take some time to read it, because that's going to help you in some ways clarify things. And then again, we're waiting on the rules that will come out in approximately, and hopefully 6 weeks. Those will provide further clarification to you. And then finally, and I will address this, but also, you know, take the time to get onto the Illinois Realtors webpage and take a look at the webinar series, because I've had more than one member call in and say that really helped them, that provided them, things just kind of clicked. So forgive me, I'm going to read because it's just clear, because there's a lot of language when you deal with the teams and the advertising and the proposed rules. But the main concern has been whether this new law requires the team or the individual name to be smaller than any subtext that might be written underneath or within the sponsoring broker's logo. So revisions to the rules and the proposed language in the rules will help everybody with this. And we feel fairly confident that this is going to be the language that will be included in the rules. The proposed new sections of the rules make it very clear, for the purposes of interpreting the new law under section 10-30 subparagraph F, that a logo, emblem, label, trademark image, or similar identification used by the sponsoring broker is not part of the legal or the assumed name of the sponsoring broker. But if the logo contains the sponsoring broker's legal or assumed name and in the case of the franchise, including the franchise affiliation, and the image is equal or larger to the team or individual's name, that will comply with RELA. There are certain safe harbor provisions that have been negotiated, and those are, if the font size that's used for the letters in the sponsoring broker's legal or assumed name is the same size or larger than the letters used in the team or individual licensee's name, or if the area in terms of height and width containing the sponsoring broker's legal or assumed name is at least the same size or larger than the area in terms of height and width than that of the team or the individual licensee's team. So I realize those are a lot of words. What I recommend doing is, if you have a proposed logo / advertisement and you're working with a logo, if you're concerned about the size, take the language and have your attorney give you a legal opinion on whether or not it's compliant with this language that will be in the rules and comply with Section 1030 of the Act. Another big concern and a big change is that Section 1030A includes these prohibited words when it comes to team advertising and designating teams. And those include words like company or realty or real estate, those words that convey to the public that it's an individual licensed entity. After talking, with Illinois Realtor, talking to IDFPR, the new rules may address this, but we have come to the conclusion that if you use the word team at the end of your team name, that will help quite a bit. So if you have the Betsy Urbance real estate team or Annalise Fierstos realty team at the end, that can cure a defect in the name that's inserted the term real estate or realty. So I realize that the long language with respect to some of this it does get complex. Again, revisit the webinar and take a look at the webinar. And when the rules come out, those safe harbor provisions will make everything much clearer for everybody as well. I'm going to turn discussion back over to Betsy.
Okay. With regard to consumer protection, we're into that final category, and we did actually receive most of the questions that we received prior to this session would fall into this category. One was a question, and forgive us if we have sort of changed the terminology. If you're on here and you're like, oh, this may or may not be my question, but it wasn't verbatim, just give us a little grace here, because we may have changed it around just to make it understandable to ourselves and to apply in a general as opposed to super specific situation, but I think you'll get the gist. But the question that came in was one about a flipper / wholesaler client that a broker had in the past, and now this client still wants to do some wholesaling, which, as we know now from the definition in the Real Estate License Act, the practice of dealing, if you will, contracts for the sale or lease, I suppose, of real estate is, if you do it as a practice and you do more than 2 of these types of transactions, you now come under the License Act. So the question that our broker had was, could I represent that person? And the answer is maybe. Let's say the client wants to do 3 wholesaling transactions or types of deals over the course of the year. Well, that person needs now a properly sponsored real estate license to do so. So that person would get the license, get sponsored, could only do it, if a new broker licensee, under the oversight of their new designated managing broker, and subject to all the rules, but they're now self-dealing. Now, as we know, a licensee could hire another licensee to represent them. So if they wanted this person and they had the license, but they wanted the person to be their broker for whatever reason, let's say they didn't belong to the MLS and the broker belonged to the MLS and they want to get it in there. And that's a whole nother can of worms as far as disclosures and whatnot when you're dealing with assignments of a contract, as opposed to really marketing the whole bundle of sticks that go along with that property. So if you want to do that, you could, as long as that person is properly licensed, and then you would have to disclose that your client is there's license interest in the property. But if they're not licensed, don't touch them, because you could be abetting the unlicensed practice in that circumstance. So, and then the other question that I think our broker had was, what about, there was a question under clear cooperation policy, which is, again, a whole nother session, because that's an MLS rule, and that's a Realtor sponsored MLS organization requirement, which is a requirement if you're in an MLS like that. But then she said, but I'm just calling flippers. Well, if you're just calling flippers and you don't have any sort of exclusive brokerage agreement or an exclusive right to sell, you may not be subject to whatever your MLS rules are, but that we'd need another set of facts. I just wanted to sort of address that portion of the question, if that the person who asked it is on the line. And now with the next question that came in, Annalise is going to address that, and we've got 4 more, and then we do want to leave time to get to these questions. So Annalise is going to talk to us about information regarding the physical condition of the property.
Thank you, Betsy. So the question that came in was, what can be shared from an inspection report with a seller by somebody who's a dual agent? And that is a party who we know is really only a messenger. They're not an advocate for either party. They can share any accurate information on the physical condition that's not confidential information. Not all physical conditions are going to be considered defective. So there'll be differing opinions. And by that, we mean that there are some physical conditions that will appear on the inspection report that may or may not actually impact somebody's thoughts on whether or not they want to buy the property. Probably the easiest way to put this would be share the facts, share the factual information, don't offer opinions, don't advocate for anything that's in the inspection report. Keep it very simple, and recite directly off of the inspection report without any editing. And Betsy may have something to add to that as well. Can you hear me, Betsy?
Yeah, I'm just unmuting myself so that now people should be able to see me. But yes, I always have something to add, so I apologize, Annalise, for the rest of your life. I was going to be like, yeah, to piggyback on what Annalise is saying. But as far as, just remember that in general, information regarding the physical condition of the property is not confidential to your client. So if you're the listing broker, you want to remind your client, look, you can ask me to keep it confidential, but it isn't by definition confidential if it has to do with the physical condition of the property. But then the fact question is whether or not it's a defective condition. And so that would have to be analyzed. And we all know, anybody who's been in the business for a couple hours knows that reasonable minds can differ on what is a defective condition and what isn't. Buyers think that everything is a defective condition, and sellers think that nothing is a defective condition, and somewhere in the middle is the truth. So we'll just leave that there. Now, as far as next question, we got this one in. Is it permissible for a broker to advertise that she'll buy your home if she doesn't sell it? And the way that I read that question is describing a guaranteed sales plan. And guaranteed sales plans are covered under the License Act, and actually they were in Section 2020, the bad acts list, prior to the rewrite. Now it's pulled out and it's in its own specific section, and I think the reason is to give some emphasis to the fact that you really, really have to follow all the very specific provisions if you are going to offer a guaranteed sales plan. It's still in the bad acts list that if you don't do it right, you could be in a heap big trouble. So what are some of the things you have to do? You would negotiate the price with your potential client prior to entering your listing agreement. So it's different than if you're already in a listing agreement and then you've submitted the property to the market, and now you as the brokerage professional have an idea what the market looks like and you offer to buy it from your own client. That is clearly prohibited self-dealing. So you can't do that. But you would negotiate a price that's acceptable to you and this prospective client, and you would enter into this agreement prior to the listing that if it doesn't sell in a certain number of days, you will buy it. You also have to prove to that seller that you have the financial wherewithal to buy it. You have to have in your agreement that you're going to market it regularly as you would any other listing, and you are not permitted to buy it until that listing is over and done. So, and also I think that if you mess up in a guaranteed sales plan and the person that's harmed files a complaint against you, I would advise you to have a good attorney and have all your ducks in a row, because as a matter of consumer protection, the agency is going to be quite protective. So I will leave that there. Now, to wrap up what we have prepared, we have two more things to talk to you about in the miscellaneous category, because what's a presentation without the miscellaneous category? But we got a question in that essentially said, must a broker who's diagnosed with COVID disclose? And I think the legal answer to that question is no. No one has to disclose that they've become sick, even in a global pandemic. However, to the extent possible, the designated managing broker of that broker might, with permission, but without identifying that person, like giving, oh, Betsy has COVID, but saying we have a broker in our office who is sick. So if you've had contact with brokers in our office, take all the necessary steps to protect yourself and those around you. Now, the patient can, and some do by posting on social media that they were or are sick with COVID. In that case, it's published. And so you don't necessarily have to protect their identity anymore. But you also want to the extent that you can, you want to, without harming the person who is sick, get permission and try to disclose it to those around them and let them take precautions and get tested, etc. Also, I'm going to just real quickly handle this one because we're getting a lot of questions about disclaimers, waivers, disclosure documents, all related to COVID. And the waiver documents, Illinois Realtors doesn't have one. And at this moment in history, we won't have one. I guess I'll never say never, because attorneys should never say always or never. Never say never. That's a whole big thing. But the reason we don't have one is because we are in a global pandemic. And even if you think you can prove causation of how you became sick, it will be very, very hard to prove unless you were in a cave with no contact with any outside person or piece of mail or whatever forever until you got it. So causation, just, you know, I'm grossly generalizing, but it's going to be really hard to prove. If someone gives you a waiver to sign, our advice to you would be don't sign it without talking to your respective attorney, whichever hat you're wearing. If you're a broker, it'd be your brokerage company. If you're a seller or buyer, it'd be your own attorney. Also, be aware that some brokerage companies are providing these to their brokers. Now, if the company policy requires the broker to sign it, the brokerage company's attorney is the appropriate person. If they are creating, if the company, the brokerage company, is creating waivers for sellers and buyers to sign, they need to be advised, sellers and buyers need to be advised to go to their own attorney before they sign, because the brokerage company attorney is the attorney for the brokerage company, not for the clients. So keep that distinction in mind. And then our final prepared question is Annalise will take with regard to multiple offers, and I'm going to just look at this list and we're going to run down it and answer as many questions as we can. So I'm going to shut myself up for a second here.
Thank you. Okay, the final question that came in was, can you be a dual agent in a multiple offer situation? Legally, there's nothing wrong with that. There's no RELA rule that says that you cannot be a dual agent in a multiple offer situation. However, practically speaking, it is not a good position to be in because, for example, if you are representing a buyer, a seller and a buyer, that's your buyer, and another offer comes in and something goes sideways, and Betsy uses that a lot, sideways, you're in a difficult position because somebody's going to end up upset. Somebody's going to be angry and feel like as if they were not adequately represented. So even though legally you can do that, it may not be the best business decision to put yourself in that situation. Dual agency is like that. It's very, very tricky. And so you want to be very cautious with dual agency. It can put you in some difficult, sticky spots. I'm going to turn questioning or answers actually to the questions over to Betsy.
If I can find the right spot to push. Okay, so now we've got questions in both the chat box and in the Q&A. Some of them are repetitive, so we'll try to blend those together and we'll just go firing down, down the list. First one, is there a way we can see a copy of the draft rules? Understandably, the department is very, very protective of draft rules because once they give them out to anybody, they're out to everybody. And so the short answer to that question is, no, those rules would be available for review once they are published by JCAR, and they'll be up and ready for notice and comment. And they're not ours to give, so we can't give them. So there's that answer. Then I have a question. Brokerage operating out of their home, excuse me, should they set it up as a virtual office and no longer have to worry about signage? If they're tech savvy, I would say that'd be a really good idea, because if you're operating out of your home, your chances are you're not having the public into your home to meet you anyway. And if you are savvy enough to run your office electronically through the use of a website, then you would set your website up. You sort of have to, in your own head, think about your website as your bricks and mortar office. So if I'm Betsy, I'm the consumer, and I click on your website, I should see, in quotes, your signage. I should know what company you are, what franchise you are, who you are, and it may just be the main company website. But I'm not going to be able to get into your files. I'm not going to be able to even be a client until I take some proactive steps to get further into your website and start talking to you about your seller checklist or your buyer checklist or what my particular real estate brokerage needs are. And also, I want to say, when I use buyer and seller, it's just because it's easier in conversation, but just know that the license law applies to landlords and tenants as well. If you've got a third party in between, you need to have a license to deal with landlords and tenants. So I'm just saying that generally. So that, I think that would answer that question, and you can expect those things to come up, and a lot. I think we will see the use of a virtual office. And in this moment in history where we're all learning to operate remotely, we might even see it more and more quickly. I was going to see if there were any other ones that related to that particular topic, but I don't think so. Okay, so the next question, if an agent leaves and doesn't notify the sponsoring broker, is there a fine? Possibly. If an agent leaves without notifying the sponsoring broker, number one, the agent should look at it at the independent contractor agreement, because there may be a notice requirement. So by contract, you're obligated to say. By license law and rules, you will be obligated to tell your sponsoring broker. Without a provision in your contract that says that you can take business with you, you cannot, because it belongs to the sponsoring broker. And there are very specific provisions in the act that say that if you mess with an exclusive listing, that you can be disciplined. So it wouldn't be automatic, but you would, if the sponsoring broker and the managing broker is honked off about it, they could go file a complaint against you at the department. And if you're Realtor members, at the Realtor Association under Code of Ethics, and that matter would be heard, and you are subject to discipline potentially. And then this question covers a couple, I think, I don't know if it's the same asker, but the question is, in the issue of designated managing broker oversight of the new broker licensees, is it possible to delegate the supervision of new agents to a mentor or a coach? And I think the answer is yes, kind of. So if you're a big office and you're only one designated managing broker, you're ultimately responsible. But if you have another broker or another managing broker licensee in your office that you trust implicitly to mentor a new broker, yes, but you've got to keep yourself in the loop, because you'll have to be able to show that you have direct knowledge about what's going on, and you ultimately, designated managing broker, will have the responsibility. So the answer is sort of yes with an asterisk, but you can have people assist you. Just make sure you trust those people and that you're overseeing and you're copied on everything. And I'm not saying that like it's going to be that easy, but I think you get the gist of what's going on. So then another related question, I think, was, is the signing of the exclusive brokerage agreements. And the question is essentially, can the new broker licensee bind the company? The answer is no. So the managing broker or somebody else in the office that the managing broker can appropriately delegate signing authority can bind the company. That doesn't mean too many negatives here. A new broker can be a designated listing agent, but they just can't bind the company to the brokerage agreement. So that's different. You can be a legal agent for someone and still not be able to bind the company to contracts. That makes sense. Hopefully that does. Must a client reveal they have COVID-19? Answer to that question is no, they're under no legal obligation to disclose it, but if they're a thinking, feeling human, they should disclose it. And if they do disclose it, there's a whole mess of questions that come about as far as health and safety and declining service in this current health and safety concern versus whether or not this person should be treated as one with a disability and make a reasonable accommodation for that person to provide the service, maybe in a completely remote way, if that's possible. I'm oversimplifying, but I think you get the gist of where those questions, there's this balancing act that's going on right now while we're in the situation. You can make consistent decisions, policy decisions, questionnaire decisions, and treatment decisions in the current emergency, but going forward, this may very well end up being considered a disability, thus a protected class, thus no discrimination under all of the fair housing guidelines and all of those regulations that we're under. So those are some of the things to consider. We've written about that. There are other resources out there. National Association has a great checklist on fair housing and how it applies in the pandemic situation. We have some information out there, so I'd encourage you to go look that up. Let's see. I have one that says, can you clarify if an address of the company must be included in licensees advertising, or is the company name sufficient? You won't see anything in the license law, current rules, and you probably won't see anything in new rules about a specific address being required in advertising. Your advertising has to be true and not in any way false, deceptive, or misleading. You have to have the company name. You have to have the franchise affiliation if there is one. Now you have to meet the size requirement. If it's a licensee's advertising and not just general advertising of the company, you'd have the name. You probably elect to have a phone number, but you don't have to. You probably elect to have an email address, but you don't have to. And you may elect or may not elect to have a street address, but you don't have to. But you want people to be able to find you. So that's up to you and your company office policy. Oh, here's one. Let's see, 30 days, sign the document. So the time is gone. That was not a question. Can a designated managing broker require an agent to get tested for COVID? Dude, that's a question of first impression, and you can try, but if I'm an agent, I don't have to agree. And then the question as to how you treat me if I don't agree could get very complicated. So if you're a designated managing broker and you want to require all your licensees to get tested, you go talk to your attorney first. That would be my answer to that question. Let's see, I had a follow-up question to, based on what we've seen in proposed rules, do we think it would be possible to operate a virtual brokerage in a high-rise condominium where the condo building prohibits the posting of exterior signs? Yes, because if you're operating completely remotely through the use of your website, now you may have other prohibitions in your high-rise building about whether or not you can traipse people up and down and into your actual condo unit for purposes of running a business. But as far as advertising and not having to post a sign, no, because your office is on your computer. And so your in quote sign is your website. So that is, and I think there will be a little bit of confusion there as we change over. And I think we can, I'm not positive about this, but I almost think we can expect the department to have virtual practitioners will have some sort of different identifier, so that the department is not looking for a physical office. So they might have a different prefix on their license or something that will show them, oh, look, these people are virtual. So if I'm an auditor or an investigator, I'm going to need a set of credentials to get inside their virtual office door. Somewhat like, as I understand it, the IRS audits big giant companies completely remotely. They don't ever go to the company. I just say that because I know some guy, but I can't divulge his identity or that would be awful.
And Betsy, I don't mean to interrupt, but on the virtual office, can you expand for the members and the people about the fact, the rules versus what's in place right now, and how quickly should they move to the virtual office platform, and shouldn't they be consulting with their attorney? Just making that clear that the way things stand right now, an attorney should be consulted before they take that plunge.
Absolutely, that's a very good question, because at the high level, I think the department and industry agree that virtual offices are already allowed by the License Act, and we'll stand by that. However, we can't promise or guarantee that if there's an audit or an investigation, that an auditor or investigator, they might say something like, oh, well, you can't do anything on the virtual platform until the rules are in place. And if I'm your attorney, which I won't be your attorney, but if I am, I would say that's hogwash. And as long as you can demonstrate how you are electronically complying with all of the Real Estate License Act provisions, which will be another fact question, because they might say, okay, you can have a virtual office, but how do you protect the confidential information in your electronic files? But that is, Annalise is exactly right. If you are switching over to virtual right after this session, go talk to your attorney first, look at the provisions in the Act in Section 5-45 and figure out how you can set it up. And I have 2:59, so we may have 1 minute left. And ask the selling leasing. Let's see. You know what? We have other questions that we have your names here. So I think what we're going to do is just wrap it up. And if we have a question here with your name that we can answer separately, we'll certainly do it. But I think we hit just about every question that we could in some way, shape, or form. And as our creative folks are wont to do, they change the facts like the law professor in your law school class. Yeah, but what if? So we'll try to answer you outside of the course of this presentation. And on behalf of Annalise and myself and all our behind the scenes helpers that make this all work for you, we sure do appreciate the fact that you signed on today and spent some time with us, and hopefully you picked up something you can use. Thanks very much.
Thank you, Betsy.